I'm going to talk about the offence of failing to provide a specimen for analysis. The legislation is set out under the Road Traffic Act 1988, Section 7.6. And Section 7.6 provides that it is an offence if an individual without reasonable excuse fails to provide, when asked to do so, a specimen of either breath, blood or urine for analysis. The reasoning behind this offence is this. Under the Road Traffic Act 1988, and particularly under sections 3, 4 and 5, it is an offence for an individual to drive or attempt to drive or be in charge of a mechanically propelled vehicle whilst they are under the influence of either drugs or alcohol. This means that if an individual is asked to provide a specimen of either breath, blood or urine in order to facilitate an investigation to ascertain whether or not they are over the prescribed limit, if they fail to do so when asked, they will commit a separate offence under Section 7.6 of the Road Traffic Act 1988. And the logic for this is quite clear. Without this offence, a person taken to the police station and required to provide a specimen of either breath, blood or urine for analysis could refuse to do so, and then of course it would be harder to prosecute a case without the evidence of how impaired they were, how much over the limit they were. And so therefore Section 7.6 of the Road Traffic Act was passed to provide a separate offence of failure to provide a specimen for analysis without reasonable excuse. Now, the reasonable excuse element provides the opportunity, if an individual genuinely has a reasonable excuse as to why they have failed to provide a breath, blood or urine sample, it may be that they may have a defence. So, for example, if a person is asked by police to provide a breath sample and that person fails to do so, but they have a reasonable excuse, such as asthma or bronchitis, it might be that they may wish to raise that as a defence at court, and it might be that they are not guilty of the offence because they had a reasonable excuse. Likewise, if they are asked to provide a blood sample and they have a physical or psychological reason why they have not done so, why they have failed to provide a blood sample, provided that they could demonstrate to the standard required that they had a reasonable excuse, it might be that they would have a defence, and likewise with urine. Under the Magistrates' Court's sentencing guidelines, this matter can only be dealt with at summary hearing, so it can only be dealt with at the Magistrates' Court. But the magistrates do have a wide variety of sentencing options available, and it would depend, of course, on the seriousness of the offence, the seriousness of the harm caused, if any, and the culpability of the individual concerned. At the lower end of the scale, an individual pleading guilty at the first opportunity with plenty of mitigation and low culpability, it may be that applying the Magistrates' Court sentencing guidelines, they may possibly receive a Band B fine and be disqualified from driving for 12 months. Whereas at the top end of the scale, for an individual who has been convicted for the second time in 10 years, who has run a trial, who has lost the credit for early guilty plea, it might be that such an individual could potentially face a disqualification of up to 60 months and could also potentially face a period of incarceration, custody, of 26 weeks. So there is a wide variety of sentencing available to the magistrates for an individual who either pleads guilty or is found guilty of an offence under Section 7.6 of the Road Traffic Act 1988, failure to provide a specimen for analysis.